My name is Brad Smith. I'm the District Attorney for the Piedmont Judicial Circuit. At the table with me is Patricia Brooks. She's the Assistant District Attorney that was one of the Assistant Attorneys that tried this case that we're here about today. There were 5 reasons that the judge in this case granted a new trial on his own motion. I would like to start with the 5th reason, the general grounds, because I believe that's the most important issue that we're here about today. Code section OCGA 5-5-20 says that a new trial can be granted if the verdict is contrary to the principles of justice and equity, and OCGA 5-5-21 states if the verdict is decidedly and strongly against the weight of the evidence. That's the reasoning for the general grounds. The best case we found was this court's case, State versus Hamilton, in 2016, 299 Georgia 667. In that case, Your Honors, the court said that the discretion of a trial judge to award a new trial on the general grounds is not boundless. It is, after all, a discretion that should be exercised with caution and invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. All the cases we could find, we could not find one where a judge granted on the general grounds that was overturned. But every one of these cases say that this power is not boundless. The problem is there is no boundary set yet by this court. Now, we have to, in our thing, show that the law and the facts demand a verdict in this case that was given. And I'd like to briefly go over the facts in this case. The defendant in this case, Paul Hamilton, owned property in Barrow County at 1302 Charlie Hall Road. He did not live there, he owned the property. There was an abandoned trailer there that had not been lived in for a few years. His daughter, grown daughter, allowed some friends of hers to hunt on that property with Mr. Hamilton's permission. On the day in question at 7 o'clock in the morning, 3 hunters arrived at that property to go hunting. They found a U-Haul truck parked in the driveway. And when I say driveway, we're out in the country. This is a wooded lot with a road, dirt road cut into it. You can't even go around it. There's trees on all sides. And there's a U-Haul blocking it. There's a woman standing at the back of the U-Haul. There's words exchanged between these hunters and that woman. The U-Haul starts up, throws in reverse, and slams into the truck that one of the hunters came in. Shots were fired by the hunters. The U-Haul flees. It goes up Charlie Hall Road about 200 yards, makes a right onto Old Hog Mountain Road. When it makes that right, the door of the U-Haul is still up. Things fly out of the road onto Old Hog Mountain Road, and the truck disappears. That's at 7 a.m. in the morning. 2 hours later, around 10:30, police are at 7 a.m. after this incident, the hunters call the police and they call the defendant, Mr. Hamilton, to the property. 2 hours later, the police are called back out there because they have found a purse and a cell phone that they believe belonged to one of the perpetrators that was there. At this time, while they're out there, the police are out there at 10 o'clock, or 10:30, excuse me, Mr. Hamilton says, if they come back here, you're going to need to call a coroner. An hour later, the 2 people that were in that U-Haul, Brandon Lay and Teddy Taylor, have gone to a 3rd person's house, a friend of theirs named Judy Hewitt. And they have asked her to drive them back up to Old Hog Mountain Road to get some of their stuff that had come out of the U-Haul. Judy Hewitt, who was not involved in the earlier incident with the hunters, takes them in her single cab truck, a Ford Ranger, that has the 3 of them in it. Judy Hewitt is driving. Teddy Kaler, the girl that was at the original scene, is in the middle, and Brandon Lay is on the far side. They go up to Old Hog Mountain Road, which again is about 200 yards up the road from the residence where this happened. They park on the side of the road and they get out and they start looking for stuff. Again, this is 3 hours after the original incident. At this point, Mr. Hamilton has gone looking for the U-Haul. He's driving around looking for it. Once they get there, some people tell Mr. Hamilton that some people are up there picking up the property that had fallen out of the U-Haul trailer.
Mr. Smith, I know I'm breaking your flow, but just because you have already previewed for us that there's a difficult standard here.
Yes,
there's a difficult standard for us when we're reviewing the general grounds on appeal.
Yes.
Can you focus in on what happened when Mr. Lay was shot?
Yes.
And in particular, I'd like to hear about accident.
Yes. When Mr. Hamilton gets up there, he blocks these 3 people in. He doesn't know who they are. He's not been told that they are the people from the earlier incident. In fact, Judy Hewitt wasn't. He blocks them in so that they can't leave. They now are all back in the truck in the same seating arrangement as earlier. He gets out of the car with a loaded weapon, goes up to the car, puts his hands in the car to try and take the keys out, and puts his other hand in the car. He says Mr. Lay grabbed his hand, his arm, and that's when he fired the shot. Now, when the officer arrived on the scene...
Does he say that's when I fired the shot, or does he say that's when the gun went off?
He does say the gun went off, but he also talks about I pulled the trigger. And another thing you need to look at is he did an actual reenactment. He went out to the scene. So you have his words, but you also have his actions, and you can see him do the pulling the trigger. When the first officer arrived, I'm sorry.
The judge's order granting the motion on general
Yes.
grounds, though, specifically references the court's perception of the credibility of specific witnesses.
Right.
When we consider all of these, when we consider what the evidence was, we're not doing a Jackson versus Virginia assessment of considering the facts in the light, most favorable to the verdict. We're doing it presuming that he drew all of these credibility determinations in the direction of his order, right?
Right, and what I was going to say in my factual dissertation is, when the first officer arrived on the scene, Mr. Hamilton told him that I got out. Let's see what I got here. I want to get it exactly right. He says to the first officer on the scene, and this is his quote, I shot him deader than shit. Nothing about an accident, nothing about the gun going off. That's what he said, I shot him deader than shit. When he's interviewed the first time by the investigator, he says, I had my weapon in my hand. It was through the window. I reached in to get the key out of the switch. He also says in that interview, I was going to fire and try to shoot through the window, not at any individual.
So let's take all of these things as true, as I think we must, all these credibility findings. Let's presume that everything Mr. Hamilton said is correct. What I'm interested in is is there any legal rule that would have demanded a contrary result? So
Yes.
Okay, so
Yes.
let's talk about that.
Because what I'm saying is, these are what Mr. Hamilton said happened.
Those are credibility determinations that the trial judge, look, what I'm asking here is in self-defense, for example, there are circumstances where as a matter of law, self-defense can't apply if you're the aggressor,
Exactly.
right? Is there something like that correspondingly
Absolutely.
for accident here?
Absolutely. There was not an accident. He was acting criminally negligent. If you go into a bank and rob the bank and say, give me your money, if the gun accidentally goes off, you're just as guilty. That's still an armed robbery. It's still a death in the commission of that armed robbery.
Hold on.
What we have here is an aggravated assault,
Well,
and someone died.
Let's talk about that.
Yes.
Is there anything criminal? Strike that. He had under some version of the evidence presented at trial, he had some reason to think that these people in this Ford Ranger may have had something to do with the trespass and or break-in at his trailer.
Absolutely.
Is there any crime against him confronting them in a public place on the side of the road?
There is a crime of him. He does not.
Confronting them in the sense of going up and talking to them about it.
Not at all. But what he did was block them in.
Is there a crime in him carrying a gun with him?
Not at all. But there is a crime of him taking this gun, sticking it inside the window of their private vehicle with the intention of shooting out that window, which is what he said his intention was. Shooting out the other window, the far side window.
Is it as a matter of law aggravated assault if there are people, strangers, inside of a car and you stick a loaded gun in it no matter where you point it?
If you're sticking it in the back seat, I would say probably not. But if there's 3 people in a single cab and you're at the driver's window, pointing the gun in the driver's window as you're trying to take the keys to that vehicle away from a private citizen.
Did he say he was pointing it at the window? I mean, I knew there
Yes.
was. Okay.
Yes, he does.
I thought there was maybe saying he was reaching.
If you have to look at the reenactment also and watch his motions. But he talks about when he reached his hand in, his other hand came through, and he does the motion with his
then
hands.
let's presume that the trial court, who was the 13th juror here, decided that he wasn't pointing, he was just reaching. Does that change your argument?
The problem we have here is we don't have any of that. And that's the problem with this case when I was talking about the boundaries. In every other one of these cases with the findings, the judges had a hearing. They had enumerated what it was they were talking about. They talked about...
Why does the judge, I mean, you also complained there was no transcript. I mean, the judge is the 13th juror.
Yes.
I mean, it's nice if he gives you a chance to weigh in on your views on the general grounds, but there's nothing in the statute that requires it. And we don't make jurors wait for the transcript to read the transcript and decide what to do. And we don't make jurors give a lot of detail for why they reach their conclusion.
Because this type of ruling is not a normal ruling a judge gives. Our entire system is based on jury verdicts. What he has done is overturned a jury verdict.
And that is exactly what the general grounds allow.
Exactly. I'm not saying it doesn't allow. What I'm saying is that is a huge power. And so the courts at this point have upheld that responsibility to that power, which is why when you see these, there are detailed reasons. They don't just say there's inconsistencies. Every trial has inconsistencies. They don't just say credibility issues.
Does that demand a different result?
I would believe...
Or is that just your strong preference and it would be a good idea?
I believe that the facts of the case demand the result.
On what do you rely that Judge Motes should have put in his order, that he should have put more in his order than he did relative to his questions concerning the credibility of witnesses?
Do you mean what case law I rely on?
On what legal authority do you rely on for the proposition that his order is insufficient?
There isn't. That's the problem. That is the problem with this power. It is such a great power to overturn a jury verdict, which is what our criminal system is based on, with no guidance and no reasoning.
That's a common law thing that has happened even before the statute.
Even before this court.
That's what I'm saying.
That has been a superior court power
It has.
in Georgia since before we've had any appellate review.
It has. And what we found is they all say it's not boundless.
Right.
But there's never been one that's been overturned that said you reached the boundary.
Well,
But
actually,
tell us why this one is.
we sometimes, as Justice Warren was saying, there are bounds if there is some legal error involved
Yes.
in the exercise of discretion.
What I'm saying here is, if you look at what the defendant said happened, that is an aggravated assault, which constitutes felony murder. There's no issue of was his credibility at issue. Were there inconsistencies in his statement?
Counsel,
Yes, ma'am.
you are understandably arguing why he's guilty.
Yes.
But it is not sufficient for us to agree with you that he is guilty. It seems to me that you have to convince us that no rational jurist could look at this record, hear this trial that we didn't hear, that we didn't see live, and come to the opposite conclusion. That's a very different thing than saying, I think my case is conclusive. It's a very different thing to say that it is impossible for Judge Motes to have listened to, seen the witnesses, consider all the things that happened during trial, and decided this is not a just verdict.
With all due respect, I don't believe that would be the standard. The standard isn't would any rational jurors, it's not possible for any rational jurors to do this. The standard is that this discretion should be exercised with caution and invoked only in exceptional cases.
But that's a description of how the standard has been applied.
Right.
I think, I mean, what Judge Justice Bethel has said, I don't think is the exact verbatim quote for what the standard is, but it's awfully close, and they might be two sides of the same coin.
Here's the problem.
If
there are
the
no
law and evidence demand something, then no rational juror would find to the contrary.
Correct. And what I'm saying is, if you look at the facts of this case, he talks about credibility. The hunters were on the scene. There was some disagreement about who was standing where, but no disagreement about pulling of triggers and where the gun was.
Is your strongest factual argument the fact that, or your representation that he was engaged in an aggravated assault at the time?
Yes. Also, criminal negligence precludes the use of an accident defense also.
Which aspect of aggravated assault? Intent to inflict a violent injury or putting people in reasonable fear of injury?
Putting people in reasonable fear. You could argue both,
Okay, was there evidence that people saw the gun pointed toward them before it went off?
Yes, Judy Hewitt and Teddy Taylor talked about the gun being in the vehicle.
What if the judge didn't believe them?
Mr. Hamilton said he put it in the vehicle.
He put it in the vehicle, but putting a gun into a vehicle or holding a gun up here does not make an aggravated assault. You either
Again,
have to
there's
have
a
an-
video, though. He's not doing this. He shows you what he's doing. He's not just talking. This is not a
you have
theoretical
to have
argument.
either an intent to inflict a violent injury. Where do you get the intent to inflict a violent injury? Because he said he
You could infer by the act, what happened,
But the
that
fact
he
that
intended to
the
shoot
fact that you
randomly.
could infer is different than
Right.
must infer.
right.
Well, what I'm
Inferences
saying is
by
I'm
their
not-
nature are choices.
I'm not conceding that he meant to shoot him. You can infer that. But even if you don't find that, a single cab truck with 3 people shoulder to shoulder, putting the gun in the driver's window, shooting across 2 women
Mr. Smith, I
and
think
striking the man on the end.
anytime you're trying to retry the case to us, and I get it, you prosecuted the case, I understand, but anytime you're trying to rehash those arguments, you've probably lost us, because that is what the general grounds allows the trial court to disbelieve. Any explanation, they can disbelieve it. So I think your better argument, and the one that I'd like to hear about in your remaining time, is any kind of reason that precludes as a matter of law the conclusion that the judge came to here. And
Yes.
so I think that turns you to your accident.
There's no conflict in the evidence as to what he did. There's conflict about what happened earlier, but none to the that is an aggravated assault. There's no accident defense because he's either criminally negligent or criminally culpable.
Let's talk about the criminal negligence. What constitutes criminal negligence based on this fact pattern?
Sticking his hand with a loaded gun with his hand on the trigger inside someone else's private vehicle with 3 people in it while he's trying to get their private property of keys from their immediate possession. That is criminal negligence at the least.
And are there other cases that you can cite to us, and some of them may be in your brief,
They are in the
where
brief.
similarly criminal negligence has been found under circumstances like these?
Yes, there's one case, I don't remember the name off the top of the head, it is in the brief, where a man gets in the bed with a loaded gun and it goes off and shoots his, I believe it was his wife at the time.
Do you recall if that precluded an accident defense in that case?
Yes, and that was argued at during the trial also about whether or not they were going to give an accident defense. The judge did give the accident defense, but that was argued during the charge conference at the trial level also, and those cases were presented at that time also. I will say this, the trial judge, and this is probably my strongest argument, the trial judge purposely surprised the state. It wasn't that he just didn't have to have a hearing. He purposely surprised the state. If you look at the transcript, he says to the assistant district attorney at the time, I know the state's just as surprised as I was when the verdict came down. He did that on purpose to surprise the state, which is not a good look.
That may be, but what's illegal?
Well, I'm saying it's legal, but it goes towards his intent. There's no hearing at all. And number 4 in his errors, I'm talking about the 5th.
What would a hearing do? I mean, I don't understand. When you say hearing, you mean oral argument hearing, right?
Any sort of opportunity for the state to go through this. He lists his
You could
reasons.
have filed an MFR, a motion for reconsideration.
We did, Your Honor. We ran out of time. This judge retired a few days after this. The new
doesn't-
judge wanted a continuance for a chance, and we ran out of time. We would not have been able to appeal it. So we did file a motion for
You can ask the judge
reconsideration.
to extend the time to appeal for 30 days, right?
We did. He did not, Your Honor.
Okay,
So we
well-
had to do this. And what I'm saying is, he does give one reason. Okay, if you look at his things in his oral to the court, when he's giving this thing, he says inconsistencies and credibility, but doesn't say who it is, except for one time. He says, pull this here. I want to get it quote right.
The hunters, the firearm experts, and others.
That's in the written order. In the verbal order on the transcript, page 10 of the sentencing hearing, he says, this is the only time he mentions a witness and what the testimony was. He says, I remember one witness not admitting that methamphetamine would have affected her perception of any of these events at all, and that troubled me. The only thing inconsistency or incredibility says, I remember one witness saying that methamphetamine would not have affected her perception of any of these events.
You know, we have...
That is not, excuse me, Your Honor, this is an important point. That is not in the trial transcript at all. That is imaginary evidence. Teddy Taylor is the only witness that talked about methamphetamine use. That question was never asked of her. She never said anything about that. That fact is imaginary. It did not happen. Please look at the trial transcript. He lists one thing one fact, and it's not in the transcript. And there is case law that says if your factual basis is incorrect, the deference given to you is less. And that's in our brief also, Your Honor. Thank you.